Oh gosh, some people have put some proper last minute questions in. Okay, I'll try and figure them out. Um, right, yeah, we'll be up and running any minute. So, welcome everyone. Let me just do the usual stuff just whilst you're waiting. I've got to get these little tick boxes at the back office done properly. Hope you're all well. I'm full of cold tonight, so I apologise for sounding rather nasally and even more annoying than normal. Um, Let me get, oh, what's it doing now? That's cool. Right, so I'm nearly there. Hold on. So put that there, pin that, and we're good to go. Okay, yeah, cool. So it's just us three tonight. Shannon's not feeling too well. Excuse me. As always, we're going to work through the questions in the week that came in anonymously. We've just had a last minute question, which I've just seen pop up in a notification. So I'm going to just have a look at that in a second. But I think there's like 6 questions that have come in. So we'll deal with the anonymous ones first and then get on to ones from the live chat. So welcome everyone. If you're regular or if you're new, say hello in the chat. It'd be nice to hear from you. And a little bit, so just a little bit of it's not really news, but just something you guys might be able to help me out with. The training I regularly deliver online, I'm gonna start delivering or start offering free places for elected members, like so councillors and MPs and that sort of people, you know, like elected people. Just, I guess, just with the hope of kind of maximising impact, because obviously councillors have quite a lot of power when it comes to local authorities. My thinking is if they understand the law, then at least they can kind of dodge the flim flam they get from a lot of council officers who tell them the wrong end of the stick a lot of the time. So I'm just going to put if I just get the right thing, I'm just going to put the Eventbrite link into the chat. And where am I? No, I'm not. Hold on. See if I can find that. I did have it, and now I don't. But yeah, so basically, the Eventbrite page has got like the dates. The next date is like the uh, 24th of Jan, then it's 28th of Feb. So you know, there's kind of course outline and stuff on the Eventbrite. So that's the best way to find stuff out. But if councillors want to come to it, they just need to email me directly. The contact details are all there. But if you've been in contact with any councillors at any point during your, you know, interaction with councils, please do send it to them because, as I say, in Bedford, councillors can be absolutely brilliant if they just know a little bit, because they'll just be more curious about, you know, whether council's not following the law or whether it is, and that will kind of hopefully lead to systemic changes in your area. So do check that out. Other than that, I don't think I've got any news. There is an LJO decision from this week for Lambeth, which looks interesting, but I've not had time to pick it apart yet. I thought it was one where the family got compensation because the council didn't offer TA when the Section 21 expired, but it's not that. It's something slightly different. And I didn't have time to make sense of it, basically, so I didn't. But yeah, Will and Karis, you got any gossip at all from your end? So, Will, you shared some details of a Garden Court Chambers free event in January. Again, I might, if I can get a chance to dig that out, I will. But it's online, so you register, but it's free. And Garden Court Chambers are basically one of the 2 best, as far as I know, in terms of dealing with homelessness stuff. So I think it's called like, or it might be about disability in housing, something like that. It might be kind of a look at Equality Act stuff. So I'll find that link in a little bit. But if you can just search on Garden Court Chambers website and they'll be in the event system there. So how you up, Pamela? Nice to have you here. So let's get into the questions. Yeah, sorry, I didn't actually give you guys a chance to respond there. Have you got any news at all? Got Karis's cat there. Nice and but yeah, if not, let me get the slides, or not the slides, you know what I mean? The virtual flip chart up, and we'll start getting into it. So zoom in there. And so question 1, I haven't got a clue what the answer is here, but I'm hoping that Carison will do. So question 1 is, if a claim for possession is dismissed by the judge, in fact, I do have a clue actually. So if a claim for possession is dismissed by the judge because of a missing document, and the landlord has to serve a new Section 21, does the tenant have to start a new homeless application with the council if a new Section 21 is served again immediately, or is still the same homeless application rolling? What if the claim for possession is dismissed more than once and the landlord keeps serving Section 21? At what point in the process is the applicant considered homeless by the council? If the situation keeps going on for nearly a year, which I've seen before, Section 21 served, expired, claim for possession, judge dismissed it, and all over again and again. So that's the situation. So my answer to this is that the application could only close if the council issued a not homeless decision. So if they haven't issued a not homeless decision and the landlord issues a fresh Section 21 notice, then potentially you're still homeless. But what I would say is a competent housing officer should have identified that the Section 21 was not valid the first time. So whatever missing document it was or whatever, that's really the first thing they should be looking at, because it's in their interest to basically say you're not homeless and say, say it's invalid notice, you're not homeless, therefore there's nothing we need to do, because they hope you will then go away and not come back. So that's my answer to it. Will or Karis, do you want to add anything to that at all? Am I roughly right with that? Let me zoom in a bit as well so you can see it a bit better. Anything to add, Will?
Well, I mean, I agree with you there. I mean, I was just thinking about it while you were reading through the question, that we've had this conversation a few times, or a related conversation about when a valid Section 21 notice has been served and the council failed to treat the person as homeless. I mean, you say a good housing officer, I could add to that and say a cynical housing officer could say, we don't accept that the notice is valid, and therefore we don't think you're homeless for the following reasons. And they could just be wrong about that, but it would be difficult. You'd then have to go for a review. But I'm missing the point of this precise question. Is if they hadn't, as you say, if they hadn't issued a decision and then a new Section 21 notice was served, then they'd have to make a decision based on the facts as they were at the time when they made the decision. But I guess it would just be a question. Otherwise, if they'd made a decision and said you're not homeless, you'd just be going back and saying, hello, it's me again. But I think in this scenario, they'd say, look, this guy's issued so many Section 21 notices that we are just going to say we're not prepared to accept on the face of it that it's valid. And you have to go for a wait till you get a possession order, whether you could challenge that or not.
It would be in that situation, it would kind of be in your interest that the council do allow the same homeless application to keep rolling, because they're kind of governed by timeframes and the relief duty and so on. So, I mean, I guess this would all still be in prevention duty.
And they take into
it would be, sorry, Karis, go on.
They take into account the stability of the housing situation. So if you're stable and it's reasonable to say repeated legal threats of eviction, it creates that instability. So they would, depending on the housing officer, be like, okay, and looking at the whole situation as a whole. If not, it's open to review.
Yeah. So let me just get up the code of guidance here, because it's an interesting one, because it's worth looking into this anyway, because this is a really important issue which many people come up against. So if we just go to so this is the code of guidance. You can Google it. It's all free. It's the council's rule book. Although it's called guidance, it's more than that. It's basically legally binding, really. If they fail to follow it, then they're essentially getting compensation claims. But if we go through to chapter 635, something like that, search for it. I can't bother to scroll through. Be here all day. 6.35. Let's not let me do it. Hold on, let's go to the next one. There we go. So, okay, so let's just read this carefully, because this is an interesting situation that will tie in here. So, the Secretary of State considers that where an applicant is an assured short-hold tenant who has received a valid notice in accordance with Section 21. Okay, so this is kind of talking about at what point you actually become homeless, and therefore at what point the relief duty kicks in. Now, effectively, what must have happened here is the notice has expired. It's then gone to the possession proceedings in court, and then the judge has realised it's not valid. So it should never have, as I say, a competent housing officer would not have let it get that far. They would have realised it wasn't valid before that, and essentially said, the relief duty hasn't started yet at the expiry of the Section 21 because the notice is not valid. And they would have, a competent housing officer would have gone back to the landlord and said, do you know what you're doing? Because you're basically wasting your own time and potentially making this person's, kind of keeping this person in limbo for way too long. Now, there was one situation I worked in, there was a similar to this, which actually was a good outcome. So same situation, mum of two made an application. It wasn't valid. The housing officer didn't pick up on that, but this was before the HRA came in. So that the main duty had been accepted. And we went to court 4 times, and each time we just said it's not valid because the landlord again hasn't got this right. And what that basically did was it bought enough time for the family to get an offer of social housing before they actually had to leave their long-term accommodation. So they didn't have to go into TA, which was a good thing for them. So although it was kind of stressful, it was a good outcome in that situation. So that's what I mean. That kind of, yeah, the housing officer should have picked up on this, I guess. So you shouldn't be in this situation where the landlord keeps doing it. But yeah, obviously the situation is there. So so if we go back to our original question, the only way the original homeless application would stop is if they issue a Section 184 notification that says you're not homeless because the notice isn't valid. If that hasn't happened, it's still the same application going through, but you're in a bit of an uncertain situation because, as I say, you should never be in this situation. You should either be in prevention duty before the Section 21 expires, or if it's valid, you then go into relief duty once the Section 21 has expired. In most cases, as we saw in 6.35, I didn't read it all out, but you can go back and have a look yourself. In fact, it's right there in front of us, isn't it? So yeah, so basically these 3 criteria have to apply for you to go from prevention to relief duty stage. And actually, what that basically means is that is the point when you should be offered Section 188 accommodation, temporary accommodation, or emergency accommodation. So, but there's 3 criteria. So all of these have to be met for you to be homeless at the point of the expiry of the Section 21 notice. I'm sorry I'm using so much jargon. There's no way around it. So the notice must be valid. There must be no chance or no kind of plausible chance that the landlord will rescind it because they're dead set on evicting you, and there would be no defence to an application for possession order. If those 3 apply, then you should go from prevention duty into relief duty when the Section 21 expires. Therefore, there would be reasons to believe that you might be homeless, might be eligible, might be in priority need if you've got kids or whatever, if you're in priority need. And so Section 188 accommodation should be issued at this point. But obviously it's a mess. So, I guess the short answer to the question is they need to issue a Section 184 letter saying you're not homeless. If they haven't done that, then you're kind of trapped in this rather unpleasant limbo state. And I guess I would consider complaining at this point or doing something to say, look, you guys need to get your act together and really, kind of process this application properly and stop leaving this in limbo, because no one's getting help by doing that. It's not helping, not helping the council either, really. So yeah, I think that's all I've got to say about that question. It's an interesting one, but yeah, I'm sure it happens quite a lot actually, where private landlords just don't know what they're doing. So yeah, if that's that one, if that's covered, then the next question we've got from the week is this one here, which is, I have a question. I know somebody needs to write to the council because they are being asked to leave after Christmas, have been in band 3. I mean, I'm assuming here private rented accommodation, have been in band 3 for 2.5 years, not had one offer. So now we have to leave. Well, no, so now they have to leave, sorry. A bit worried because they don't have good health, physical disability, and diagnosed with traumatic brain injury. Would this make them a priority need automatically? So let's just kind of dissect this as we go. So the answer is no, you would not automatically be in priority need with a traumatic brain injury and physical disability, but it's likely that you are. But rather than it being an automatic characteristic, you need to show why you are essentially at a noticeably higher risk of harm if you're homeless than a healthy and robust person would be, using the kind of wording of the law. That's a very kind of, very sort of quick paraphrase of the definition. But clearly it would be, it's quite obvious there would be a number of ways that traumatic brain injury would impact someone's ability to deal with being homeless, whether it be even just kind of simple things about keeping themselves safe, all those kind of things. But it's all going to be based on the actual impact of the brain injury. So obviously a traumatic brain injury can be, extreme, or it can be kind of, anything on that sliding scale. And so you'd have to kind of have detailed medical evidence of how that brain injury affects you. But, that may well exist. I would probably expect that information to be available already. So they're not in priority need automatically, but they probably are, in my opinion. So you need to do the kind of the arguing. Very worried about them saying they have to go into temporary accommodation as they feel they'd be vulnerable, as their physical disability has made them weak. Also, would you be able to tell me what they're facing? They used your template in my letter. Okay. So yeah, there's a template homeless application wording, which is in one of the videos I did. I think that's what they're referring to. If they were to be accepted as in priority needs, what would the process be after that? Would they be put into one of the highest banding groups or offer temporary accommodation, would they be higher than someone else in temporary accommodation, really worried about having to spend a lot of time in temporary accommodation that's not sure they'll be able to cope with it? So we've answered the question about priority needs. So they're not automatically in priority needs. Then we're going to get into this really difficult to explain situation where we're talking about the local council's allocation policy. So at the moment, the homeless application hasn't been, hasn't started as far as we can tell. They've just applied through Part 6 of the Housing Act. So they've got onto the housing register, Part 6, they're in Band 3. And obviously in this particular council area, Band 3 is nowhere near enough to actually give you a reasonable prospect of, kind of actually getting somewhere in the time period. Now, we can only answer this to a certain extent because every council is different and we don't know what council this is yet. But if you then become homeless or you're then threatened with homelessness, so let's say the landlord has actually served a valid Section 21 notice and there's 56 days until that notice expires or less than 56 days, then you can make a homeless application. And what that does is it basically cancels the Part 6 application. So what's gone on until now basically is just annulled, and that is as if it never happened. You're then dealt with as a homeless person or somebody who's threatened with homelessness initially, and you will then get a banding just by being threatened with homelessness. But again, you have to check your own council's policy because every council does it differently. So it might be that you go to, who knows, you might go down to Band 4 initially. It might be like that. But once the council has accepted you're in priority needs, you're homeless, you're eligible, you're not intentionally homeless and all the rest of it, then they would owe you the main housing duty once the relief duty has finished, which takes 56 days at least. And you would then get rebanded again. Now, you might go up to Band 2 or you might go up to Band 1. I don't know. It just depends on the council's policy. It's possible that you might go up to Band 2 as a homeless person, as owed the main housing duty, but your disability might kind of give you an additional banding. It's just all down to the wording of the actual council's policy. So, but those kind of things aren't unusual. So you just have to check the wording. So if you search for the council's name and housing allocation scheme, you'll get the policy, and that will tell you what band you'll get as someone who is owed the main housing duty. Again, I'm going to try and unpick some of this jargon. So the main housing duty and main homelessness duty, basically, they are the same thing. They're just kind of different phrases to describe it. It's Section 193, which is the technical bit, and it's the duty that councils owe to essentially provide settled accommodation of some kind, whether it's social housing, whether it's private rented, you have no control over it really. Although if you've got a disability, it's more likely to be social housing for various reasons. And so, yeah, so if you're owed that main housing duty because you're in priority need, not intentionally homeless and so on, you'll get a particular banding, and it's just down to the council's process whether it is. Now, we can't necessarily say more than that, but what I would say is it's highly unlikely that you're going to get rehoused before going into temporary accommodation. So it's very unlikely that you're going to get such a high banding by being homeless that you're going to get, you're going to get housed in that time. It is possible. So the council might, for example, try and get you into private rented accommodation very quickly, not through a landlord or something. But that's yes, down to the council really. And if you've got a disability, then it's less likely to be suitable because private landlords don't tend to like adaptations being made to the property. So, oh my gosh, I'm so sorry that doesn't make better sense because it's ridiculous. It's utterly ridiculous the way the system works. That's my best attempt at explaining how it works. So just to try and recap to make sure I've at least tried to answer it, you're not automatically in priority needs. If you're making a homeless application because you might be homeless or you might be threatened with homelessness, then the previous Part 6 application effectively just vanishes. You'll then be dealt with according to the local council's policy, which will give you, it could give you Band 1, it could give you Band 3, again, who knows, it just depends on the policy. And ultimately, it's unlikely that you're going to get a house before the temporary accommodation, before you actually get evicted from the private rented. So that's my answer. Will and Karis, what have I missed out? What could I have said better then? Because it's just horrendous. Every time I try and explain it, it gets worse, I think.
I was just going to say about the suitability will be assessed with suitability. I don't know if you said it, sorry. If this
No,
is
I
a
didn't know.
repeat.
Yeah, go for it.
Yeah, the accommodation, if you go into temporary, will have to be assessed for if you've got a physical disability, you'd have to be assessed your health needs, and if you make a homeless application, they'll make a housing plan with you, so they'll assess your needs there, and you can get medical records on that there. And if they don't, if they put you into accommodation that is unsuitable, you can challenge it. So
Yeah.
keep an eye out and keep your records of what they're saying and what they're doing.
And yeah, and going back to the initial approach and that initial email that the template was being referred to. So, if those who don't know what I'm talking about, if you go on the channel and you search for the video, the best way to make a homes application, in the description of the video is a template letter, and I'm sure within it it will say something about identifying that you have a disability. So it might be, in that initial email, you want to say, I've got a disability and I've been diagnosed with traumatic brain injury, and therefore this is what I need from my temporary accommodation. So let's say the disability is a physical one where you need wheelchair access. That'll be kind of a really straightforward one legally. You just put in that initial email, I am a wheelchair user, I therefore need wheelchair accessible accommodation. And so basically all accommodation that council provides for you through their homelessness duties has to be suitable, as Karis said. So although they might try and put you in an absolute dive that's totally unsuitable, it's not legal and you can challenge it, but you need a solicitor. So yeah, Will, do you want to add anything to that one as well?
Well, I wanted to add something, but it may not be. It's not so much of an answer as two questions I've got here, um, which relate to this. One is, do you think anyone is ever automatically in priority need?
Yeah, so pregnant women would be, and
Okay, yeah. So
yeah,
that,
so
but they'd still have to accept that you were pregnant, which I suppose if you're in the later stages of pregnancy isn't it's difficult to deny. But if you were only 1 month pregnant and it wasn't visible, they could say, well, we need to make inquiries. So
yeah,
yeah,
yeah.
but
I'm talking about so from a legal point of view, you're automatically in priority need. You're absolutely right. Many housing officers out there, and not all of them. I just guess we need to stress that some housing officers are fine, but many housing officers out there will just be ridiculous, and they'll say, "Oh, we need to see a scan photo or a pregnancy test
yeah.
and so on." So that's not legal, but they
Sorry,
will do that.
of course, the other thing is if you've got children residing with you, then you're automatically in priority need as well. But
Yeah, yeah,
they'd
and
have to
well,
be
and
satisfied that they were residing with you.
yeah, but the other automatic ones very quickly, just since we're talking about it. So if your house burns down or it floods or there's a big sinkhole opening up in your street, or as happened in Bedford recently, there was some natural gas escape from the hillside that blew up property and killed two people, so the whole street was evacuated. All of those kind of natural disasters, or well, not necessarily natural disasters, just a disaster. So Grenfell was another one. If you're homeless because of that, then you're automatically in priority needs. 16, 17-year-olds who have declined support through the Children Act would automatically be in priority need, and 18 to 20-year-old care leavers who were a formerly irrelevant child, which I'd never understood the kind of that kind of the small print of that, but that's what the bit says. And then finally, the other automatic one is if you're homeless because of domestic abuse. But again, that out of all of the six, that is the one which is easiest for a council to push back on and say, oh, we don't believe you. So although legally you're automatically in priority needs, in practice it can be quite difficult. So yeah, sorry. Hey, you cheese face by the way. Sorry, I missed you. But yeah, Will, you said was that two questions
Yeah.
you had or just one?
My second question is, and it would be interesting to see if the person who asked this question is watching, and maybe they can answer this, is what do people understand the term temporary accommodation to mean? Because in this question, for instance, I suspect it may be that they're thinking that temporary accommodation is bed and breakfast accommodation, because the reference is made here to they're worried about not being able to cope with living in temporary accommodation. But the other way of looking at it is that temporary accommodation could be you could be in temporary accommodation for quite a long time, but it does have to be suitable for you. So you shouldn't be faced with the prospect of accommodation which you can't cope with. Um, and I think it may be in the popular mind that temporary accommodation equals bed and breakfast. Because I was looking at an article in Inside Housing, and they were talking about the number of families in temporary accommodation. And I thought, well, how are they defining this? Is that families in B&B or is it families in Section 193 private accommodation, which isn't a final offer, but they've been there but they're quite happy there. I mean, some people are. I know they're quite upset when they're told they have to move because they put down roots.
Yeah.
So my question is sort of rhetorical, but I said don't. I mean, I guess I'm trying to say is don't worry. Temporary accommodation shouldn't be and doesn't have to be accommodation that would be difficult. If you can't cope there, then you should challenge the suitability. But that may not be what you want to hear. But the problem is you're not gonna. If the alternative to temporary is permanent, The problem is nowadays it's unlikely you'll get something that is permanent. You could just get private sector accommodation, which is in a grey area, isn't it, between permanent and temporary?
Yeah. So on this line of thinking,
So it makes it
so
more complicated.
I think I mentioned it last week. So I spoke to Bassett Law as part of my little bit of working out what the average waiting times are. And the way they do temporary accommodation is they've got their own housing stock, so they council owned housing. They've got a duty to someone. They stick them into one of their temporary accommodation units, which is social housing, and then they literally just convert it into a full long term tenancy, which I think is a great way of working. Their average waiting time is like 6 days from the point of having a main duty accepted. So that's an example of a council, but yeah, that's a council which is like middle of nowhere, Nottinghamshire. It's not London, so it's very different there. In Bedford, some temporary accommodation is absolutely fine. It's nice, as Will said. Actually, people they miss it when they move on. Um, Other times it is hotel out of town, and it's all the kind of the worst aspects of it. Um, on this point as well, this is something which is worth bearing in mind. If you're I'm going to say typically a single mum who is subject to the benefit cap, the benefit cap applies when you are in settled accommodation, but when you move into temporary accommodation, it's lifted. And because many people subject to the benefit cap become homeless because they can't afford their rent, and they're not intentionally homeless because they can't afford their rent, so the council will actually place people for many years as just kind of default into temporary accommodation. But it can be perfectly decent. But the problem is that person is or that family are trapped in that accommodation until they can get out of the benefit cap. Because as soon as they move back into normal accommodation, sort of settled accommodation, the benefit cap kicks back in again. So the only way you get out of it is either by getting a job or getting too ill to work, which is another reason why you have people living in temporary accommodation for many years. And just there's a half question in there, Will. So councils report on both the number of people in temporary accommodation, and they separate it out from section 108 and 193, and they'll also specify those number in hotels. So if you search for Google homelessness live tables, you get a huge amount of information which councils report on every quarter, which is where I get a lot of the stuff I talk about, kind of average waiting times and how many families are in B&Bs with children over the 6 week limit, that sort of thing. Birmingham's still the record holder on that. It's about 600. But yeah, so there's a lot of information available that the councils do report on. So yeah, hopefully this is useful stuff for everyone. A couple more questions from the week, and we'll get into the live chat as well. So number 3, can you pay for accommodation yourself in a cheap hotel with cooking and other facilities and get the council to pay you housing benefit directly so you can pay it yourself? Now, you certainly used to be able to do that back in the old days when it was just housing benefit. The answer is I don't know how it works now with universal credit. So I used to, when I went to the night shelter in Bedford, there was a guy. He would basically do that. He would basically get paid his DLA, what is now PIP, go and stay in a hotel. He could only claim a certain amount of money for the hotel, so he could only claim like the local housing allowance for the hotel. So he wouldn't get the whole amount, but he would top it up with his DLA and wait till he ran out of money again and come back to the night shelter for you just go around the country doing it basically. So it certainly was possible. I don't know if it is possible anymore, and I don't know if Will or Karis know if it's possible now. Karis?
Sorry. Yeah, no, short answer, I think no, it's not. There's um exceptional circumstances, which is if you're fleeing domestic violence and if you're in a unique housing situation. I think those are the two exceptions where you
Okay,
can
yeah,
favour it
it's
yourself
a
and get it.
shame. Yeah, I mean, I might if I remember, which I might not do, but I'll try to. Shannon might know the answer to that. She kind of does a lot of work with the DWP, so I will, if I remember, I'll ask her and report back next week to get a definite answer. But but I trust Karis is right there in terms of it's not anymore.
It would
Um,
be try and speak to the council and see what they can do, and discretionary housing payment is all I'd add.
yeah, yeah. I mean, I guess the question, if you're homeless, even if you're not in priority need, the council still have to go through the homeless application process and still go through the relief duty, which might actually result in some help. So, as part of the relief duty, they should be able to tell you, even the housing officer should tell you whether you can do this, whether you can stay in a hotel and top it up with housing benefit, or universal credit, whatever it would be. So it's always worth making a homeless application, even if you're definitely not in priority need. So yeah, Will, you got anything to add to that one?
No, I haven't. No, no.
Just so guys, just in the live chat. So I know everyone hates me for doing this, but I am just going to delete a couple of questions. Not that they're bad questions, but they are essentially containing personal data. So ask if you could rephrase the questions and ask them as what if questions. So what if someone was in temporary accommodation for 6 months, they had kids? You'll get the same answer from us, but you don't have to put your personal data on the internet. I just think it's just not good. It's not good that people have to or feel they have to put their personal data onto the internet just to get an answer that they could get without doing so. So if that person just wants to rephrase the question, we'll get to it in a minute. Speaking of which, sorry, there's another one as well. So yeah, again, sorry, sorry, I feel bad doing it, but I'm just removing another one. Again, if you just rephrase it, that'd be awesome in the third person. So yeah, in fact, no. So that's all the ones from the week that are anonymized. We'll do the other ones at the end of the session. Again, I'm trying to get people, anonymizing their questions. So if we go to the live chat now, here we go. So this is an interesting question, actually. So should a priority client, so we're going to take that initially to mean that's someone with priority needs, denied social housing due to rent arrears, not their fault, received reasonable preference since the relief duty was accepted, and they've been waiting 2 months for a review. So really good question. The answer is yes, they should. But let me explain a little bit of context to make sense of the question. If you are in the prevention duty or in the relief duty stage, you have to be able to get onto the housing registry. It's called reasonable preference. So you have reasonable preference. What that means is you have to be on the register. It might be the lowest banding. It might be like band 4 or band D, or whatever it is you call it in your area, but you have to be on the register. And that would then presumably go up if you're then owed the main housing duty after relief duty stage is finished. Now, what can happen? I'll give you an example. My old colleague John Allen worked on in Bedford because it's a really good one in terms of the outcome. So there was he was supporting a lady who'd fled domestic abuse, had been financially abused, and as a result of the financial abuse was in several £100s rent arrears. It wasn't even that much, I don't think. But basically, the council owed her the main housing duty, so they had a duty to provide settled accommodation. However, when the council then put her forward for accommodation with social landlords, because in Bedford they sold all of their housing stocks. There is no council housing in Bedford at all. It's all housing associations, and that's stupid for a number of reasons. But so the council had an absolute duty to house her in suitable accommodation, but the housing association, which in this case was Stonewater, which is quite a fairly large housing association, they had a blanket policy which stated that they would not accept anyone with rent arrears. And so John was like, yeah, but they got rent arrears because of domestic abuse. So it wasn't their fault. We know this. We already established this. And he basically wrote a complaint to the chief executive of Stonewater and copied in all the relevant politicians. So like the mayor, the MP, all the bods. And Stonewater immediately changed their policy and basically said, yeah, no, you're right. We shouldn't have a blanket policy. We should. So essentially, the policy was changed to basically take into account the reason the person had rent arrears. And it wouldn't just be domestic abuse. There'd be other circumstances where it was just simply out of someone's control. You'd be able to prove that. So yeah, there's a further layer to this, unfortunately. So if you remember as well that just because the council owe you the relief duty, the prevention duty, or the main housing duty, even does not guarantee that you're going to get social housing. They can still end that duty with an offer of private rented accommodation. In the relief stage, it's called a final accommodation offer. And in the main duty stage, after the relief duty stage is finished, it's called a private sector discharge, probably. It's not a technical term. And so they would, essentially what you might have here is someone, they have to be in the housing register for sure. They have to be given reasonable preference. They have to be on it. They might have a relatively high banding, but that doesn't mean to say the council won't still, just as you're about to win a bid or something, you're working about the thing, they might still basically offer you private rented accommodation. And if it's suitable, you have to accept it. And if you don't accept it, then they would end all duty to you. So really interesting question. Will and Karis, have you got anything to add to that or take away if I've got something wrong? I'll take your silence as an affirmation. That's cool. Oh no. Okay, another good question here. Shame Shannon's not here tonight. She'd like this one. Hold on a sec, press the wrong button. And just let me go back to question 4 briefly. So yeah, the fact they've been waiting 2 months for a review, yeah, I mean, just to make the point, the relief duty is only supposed to last for 56 days. So if they haven't made a decision at the end of the 56 days, they're essentially delaying things. And technically speaking, you can get a very small amount of compensation for that. But yeah, it's not you want to be a little bit careful about it, whether you complain or at what point you complain about that. But yeah, hopefully that answers the question for that person. Number 5. Friend was verified as rough sleeper by council's outreach team and has it in writing, but then council claimed to not believe he was homeless after verification. Is this unlawful? Yes, it definitely is. So Section 184 of the Housing Act, which is the most important section, it's one of 2 sections you actually want to remember. So you want to remember Section 184 and then Section 188. Section 184 says that if someone essentially, if you apply for housing, you become an applicant, homeless applicant. And if you ask the council for help with housing and give them reasons to believe that you might be homeless, then the application is triggered. And it's a low threshold. So there only has to be reasons to believe that you might be homeless. So someone who's been verified by the council's outreach team is very clearly reasons to believe that they might be homeless. And so the application needs to start. The council can then make proper inquiries, and maybe they establish that actually you've got a mansion and you're lying, which is unlikely, but it's technically possible. But the application needs to be well underway. Now, the thing which really pisses me off, and I know pisses Shannon off as well, and may well piss Will and Karis off, I don't know, but is the fact that people go to councils, any department. Let's just get it up because this might sound like it's too good to be true. But if we get the code of guidance up again and go to 18.5, which is the best paragraph in the code of guidance. So he's talking about homeless applications here. Let me zoom in a little bit. So homeless applications can be made to any department of the local authority. So that could be the council's outreach team, and expressed in any particular form. So essentially, this next bit means you don't have to say it in any particular legal jargon. As long as the communication seeks accommodation or assistance in obtaining accommodation and includes details that give the housing authority reason to believe that they might be homeless or threatened with homelessness, so that reads as might be homeless or might be threatened with homelessness, this will constitute an application. So, and then if we go to 15.4, something like that, let's try that. You've then got this, what's going on? Hold on. Come on, PDF. No, that's not what I want. So just searching. I'll just scroll to it. Do it the old-fashioned way. Yeah, 15. Here we go. So this is the criteria for them basically engaging with Section 108, which is the other section you want to remember, which is the duty to provide interim emergency accommodation. And this would apply if there is reason to believe that you may be homeless, be eligible, and have a priority need. And the rate, again, you read that is you may be homeless, you may be eligible, you may have a priority need. So most people rough sleeping there will be reasons to believe that they might be in priority need just because of the nature of rough sleeping. It's possible you're going to find somebody who isn't, but they generally will be. And so it's likely that the council has acted unlawfully. Now, in terms of what you do about it initially, well, I would basically follow the information in the video I mentioned earlier. So the best way to make a homeless application, which is on the YouTube channel, because in the description, again, you've got that template writing of what you want to email the council, and watch the whole video on that because there's quite a lot in there that's probably worth taking note of. But in this situation, pragmatically speaking, I would be triggering an application via email just to cut through any sort of unnecessary stuff. You might actually be able to complain about it later and get compensation, but right now you want to worry about getting a roof over your head. So that's my answer. It is unlawful. There's obviously reasons to believe that you might be homeless if the rough sleeper team has said you're homeless, but you shouldn't even have to get to that stage, to be honest. So yeah, Will and Karis, anything to add to that one?
Got a little bit to add. Just by way of a devil's advocate. I take it you're answering that question in the sense that the council refused to process the homeless application based on their refusing to believe they're homeless, yeah?
Yeah.
But if you look at it in a slightly different way, that the council, it would be perfectly lawful for the council to process the homeless application and then issue a Section 184 notice saying, having looked into this, we disagree with the verification for the following reasons. For instance, because although you may have been homeless on Monday, we heard that you got a new tenancy on Wednesday. That would be lawful. and you just have to challenge it in a normal way. But it definitely, they couldn't just say, we don't think we've got reason to believe you're homeless. That would be completely unlawful. Yeah.
Yeah, and I think it's probably worth labouring the point about these two different thresholds that councils have to act under. So you've got this reason to believe that someone might be homeless or they might be in priority needs, which would trigger the application and potentially trigger the Section 108 interim accommodation duty. But to end that application, the council have to be satisfied that you are not homeless. So there's kind of, let's say, two thresholds. There's reasonably that you might be homeless, that kind of gets it going. But to finish that process, the council have to be satisfied, as in, they've done some inquiries, and as Will says, they are satisfied you actually have, you've got a tenancy on Wednesday, and we've got proof of that, and we're kind of happy to stick with that. So that would be the kind of way those two different thresholds work in practice. So it's a low threshold that kind of gets the process started, and it's a higher threshold that ends it. So the council have to be satisfied that you are in fact homeless, eligible, in priority need, all the rest of it to kind of end the duties. So I'm getting about 100 notifications here. I don't know why, but anyway. Hey, Andrew, nice to have you here, mate. Interesting question again. So number 7, I don't think I missed one. Just going to double check I haven't missed one, but I don't think I have. Yeah, so number 6 for this week. What are the pros and cons of accepting a temporary home from a charity shelter whilst you're in the process with the council? The council has accepted that you are homeless, have local connection and valid section 21. So really good question again. Great questions tonight. How do I answer this? So basically, the first thing to understand is that charities, in my opinion, do more harm than good, but I appreciate some might disagree with that. But what you need to initially work out is when they say it's a temporary home, what do they mean? Is it a supported accommodation unit which is available for a couple of years, or is it a night shelter? Or is it severe weather emergency provision, SWEP? Is it kind of like a bed on a church hall floor or something? That's good. So I've got about 1,000 notifications. I don't know what's going on because anyway, this is going to annoy me in a minute. I don't know if you guys can hear a beeping. If that's what it is, just my computer being weird. So so let me give an example of this to kind of flesh this out, because I've seen it once where a guy, it's actually a story I tell in the training, because he was he'd been evicted from supported accommodation for urinating everywhere whilst he was very, very drunk, and basically evicted from there. The council said he was intentionally homeless. We said he wasn't, because he had done something whilst he was very intoxicated, which meant that the 9.17 in the Code of Guidance kicked in. There was a defence against him being intentionally homeless. But he preferred to live in the night shelter whilst they carried out their inquiries and kind of messed around. So he essentially said, you know what, I'd rather be in the night shelter because I get food there and they kind of look after me a little bit, rather than just being a kind of concrete shell on my own. And the council were happy with that. Everyone was happy with that. He was happy with it. The council were happy with it because they weren't having to provide temporary accommodation. And then they overturned the decision and they offered him proper accommodation afterwards. So you can do it. But what you want to be very, very careful indeed about is basically accepting a charity bit of accommodation, which is actually supported accommodation, which it has, you have a longer term license to stay there. So like a typical like YMCA or St Mungo's or something that sort of like hostel environment. Because as soon as you move in there, you're no longer homeless, and you have, without realizing it, you probably made your life very difficult. You probably cut yourself off from a number of the options you would normally have. My answer to this would be, you can do it. The council might be very happy with you doing it. But you want to get it in writing from them exactly what that means. You want to get very, very clear, detailed analysis from the housing officer saying, if you do this, this is what it means. These are the implications of it. Now, what could also happen if we go to the case called something v Birmingham, Edwards v Birmingham, where in that case, the council owed the lady a duty to provide interim accommodation, but she said, you know what, I'd rather stay at my mum's. And they were like, cool, that's fine. But what they also had to say was, if the relationship breaks down with your mum and you can't stay there anymore, just come straight back to us because we have this duty to provide interim accommodation. So that can also be so you might go and stay in the charity shelter, but then kind of find out it's rubbish, and come back to the council, and they should basically reinstill Section 108 and provide temporary accommodation or interim accommodation. I should keep trying to say at that point. But I'll leave Karis and Will to kind of come in a bit more. But the other kind of thing to bear in mind here is the other thing that's going to be really relevant is priority need, which, you know, the person said, or the situation is that the council's accepted that they're homeless and they have local connection. The thing which everything rides on is whether they're in priority need. That's the kind of key thing. So I'd say a bit more about that. But Will and Karis, do you want to add anything to what I've said there so far? If not, I'm just going to keep dealing with these notifications which keep popping up. But yeah, Will.
The only thing I'd say is it comes back to my question about what is temporary, because you have to be very careful, because if the council don't think that what you've accepted is actually temporary, but it's longer term, then they're entitled to say, well, you're not homeless, come back when you have to leave where you are. On the other hand, so for instance, if some people may say, oh, we can give you a 1 year tenancy, a short hold tenancy, that's only temporary. Is that okay? And the council would say, yeah, that's okay, because you're not homeless anymore. You've got a property. Whereas if they said, and put it in writing, we've got temporary place for you that's only going to be available for 2 nights, and then you have to leave. There's no way I think that the council could argue that you weren't homeless. So that's what I would add to that.
And I'd just
Cool.
add about what tenancy you take on, because they could evict you without notice. So if it's the agreement you make with the charity shelter, because it will sometimes be called a license, and you don't have any rights to challenge it, and they can just evict you without getting a court order or going through any channels.
Yeah,
So
I mean, one of the reasons why I have so little time for charities that do this is that, so you might have someone, they're in priority need, they're not intentionally homeless, you know, they would be owed the main housing duty if they made a homeless application, but instead the charity says, oh no, come over here, you know, come into our thing, it's all singing, all dancing, we're brilliant, we'll sort you all out. And then the person moves in and realizes actually it's an absolute hole and it's terrible, and the charity, the staff are never there and they never provide support. And then before you know it, you've been evicted because you had some alcohol in your room or something like that, something really petty. You're now intentionally homeless. You weren't before, you would have been on the main housing duty, but now you're intentionally homeless. So now you're trapped in the revolving door of homeless services. So this is a good example of where charities actually, with the best of intentions, they really screw a lot of people over. What they actually generate is not people who are housed; they generate people who are now intentionally homeless and now much more difficult to house. So, beware of charities is my answer. Now, I know some people work for charities and they think they're great. I just disagree with it basically, and happy to love to have a debate about that, but that's probably a thing for another time, really. So yeah, I'm getting somewhere to turning off all these notifications that I keep getting through. I've realized what it was now. But anyway, yeah. So let's see how we're doing with the we've done that one, done that one.
should I
So
just say about,
oh
sorry
yeah, go for it.
to interrupt, about the practicalities of living in the charity shelters? It'll be you'll have shared facilities like a bathroom, kitchen, it's all shared. Storing food is all shared, and usually you're in a little room, so you'll share a space with strangers, and they'll have a myriad of, there'll be mental health issues and trauma and everything's going on there where they don't have access to the support and services they should have. So on
Yeah,
practical side, if you're quite vulnerable going in, you're going to be
yeah,
even more coming out.
yeah. I mean, I used to work in supported housing and thought it was the bee's knees, and then I saw the number of people who came in without really any support needs at all, and they left with with five.
Well,
And
yeah.
I saw one recently, a local charity doing a LinkedIn post saying, oh, here's little Jimmy, he's amazing. After 5 years, we managed to support him to get his own place. And I'm like, 5 years? You're a low support needs hostel, and it took 5 years to do that. What are you playing at? So anyway, as I say, that's another thing for another time. We'll talk about all day.
Mm.
So yeah, just a quick question here. What other ways are there to ask questions on this channel so I can put in advance, please? So really good question. If you put a question on any video on the channel, I'll get a notification. And what that means is you can basically, first of all, get your question asked first in this session. And secondly, there's no word limit. So you can, well, there's certainly a much bigger word limit. So you rather than kind of having to kind of make multiple messages in the live stream chat, you can just basically put it into the comment section. Still needs to be anonymized. So again, I prioritize ones that should anonymize their what if questions, but you can do it that way as well. just someone mentioned there just about having been to the MP and all the kind of local council and stuff and still not getting anywhere. Basically, it comes back to our usual kind of spiel about try and find a solicitor. And what we've been saying recently is if you go on Will's, we'll get the link in a minute. If you go on Will's website, he's got a list of legal aid funded solicitors you can approach. They're all mostly based in London, but you can get them anywhere. And it might not be the worst idea to start with the letter V and start working your way from there if that's not too cryptic a way forward. My LinkedIn's going to, YouTube's going a bit mad. So I've done that one. How you up, Flabby? So this is just a follow-on question from a previous one, which is just as interesting. Let me go back to it. So yeah, back to question 4. What if they were denied social housing during the prevention stage, around 2 months has elapsed since review, and now aware of reasonable preference, file a new complaint so they're in interim accommodation, so now they're in the relief duty stage. I guess again it comes back to probably what I didn't explain very well is it is legitimate for so social landlords can turn people down for no good reason, so they're not subject to the same duties that council. This is why councils that have their own council housing are better. Systematically they're going to be better because they have the duties and they can therefore discharge them. Whereas if you have a council like Bedford, which has duties but no accommodation to put people in, they actually put themselves in a very difficult situation. So as I say, this person should now be in the relief duty stage. They therefore should have reasonable preference. So they should be on the housing register, even if it's at a low banding. And I'd say initially, I'd probably say rather than complaining initially, just write to the housing officer and basically say, look, am I not owed reasonable preference? Should I not be in the housing register? Give them a couple of days to respond, and if they don't respond, then consider complaining. But we've talked about this before. At that sort of stage in the process, you're very vulnerable to retaliatory action by the housing officer. If the housing officer is a nightmare and completely immoral, then they might essentially punish you because you complained about them, and basically just make the whole process very difficult. I said it before. When I worked at Just Us, we would wait until someone was housed as much as we could before we'd make a complaint, because at least then it was kind of the person was safe and we can make the complaint in kind of ruffle feathers later. So hopefully that's kind of answered that question. Okay, so question 8. If someone refuses a move to a new temporary accommodation address, I guess that means, and doesn't reply after 21 days given for review, so handed a new notice to quit, what are their options? Do they just apply again or apply to another council? Okay. Let me just get that last bit in there. Right. There's no way of avoiding some jargon here. Apologise. We talk about temporary accommodation, and that means different things to different people. But legally speaking, temporary accommodation is the accommodation that someone's been offered after the main housing duty has been accepted, or technically, just to be really annoying, when Section 190 has been accepted, where the person's in priority need but they're intentionally homeless. So that's temporary accommodation. So the accommodation that you're in, that often people call emergency accommodation, but that's not a legal term, between making the application and the decision being reached at the end of the relief duty stage, technically that's called interim accommodation. Now, it might be helpful for the person just to confirm whether we're talking about interim accommodation or temporary accommodation, but I'll try and answer for both. So temporary accommodation, so you're in one temporary accommodation address, then the council says, right, you move in, we're going to move you somewhere else, and you say, no, don't want that. Bottom line is there's no way around this. You put yourself in a very precarious position, because unless you can challenge that council, challenge that offer of accommodation by saying it's unsuitable, at that main duty stage, the council can then end their duty to you. So they can, they have a Section 193 duty to provide long-term accommodation in whether it's private rented or social housing. If you then turn down temporary accommodation without a good reason, they can end that duty. Now, you can then go and reapply to the same council again, but there's a chance you'll be found intentionally homeless. There's quite a high chance, actually, you'll be found intentionally homeless. And whilst you can apply to another council as well, you might have the same problem that they would say, well, that council A had a duty to provide suitable accommodation. They're saying that the accommodation offer was suitable, and therefore we're going to say that essentially you're intentionally homeless as well. So, I guess that's why we always err on the side of caution and say people should not reject accommodation unless they physically cannot go there for some reason. Something, literally physically stopping you from going. For everyone else, they need to move in and then challenge the suitability through the review process. If it's interim accommodation, so if it's accommodation before that decision has been reached, then the council would end the interim accommodation duty, so they wouldn't have a duty to provide you accommodation until the decision's been made. But then if there is a positive decision at the end of it, the main housing duty is then accepted, their duty to provide temporary accommodation would then kick back in again. And so effectively, it wouldn't have a long-term bearing on your case. So you wouldn't be intentionally homeless from rejecting interim accommodation, but you would be potentially if you were rejecting temporary accommodation without good reason. So, Will and Karis, do you want to add anything to that one?
Just
possible. So the person's confirmed that the council owed the main housing duty.
Quickly add to this. What should happen if you refuse something, then the council treat their duties towards you as discharged because you've refused it and you missed the chance to review it, but you were owed a duty before, then when you get to the stage when the council are going to make you homeless again by evicting you from your current accommodation, you can make you should make a fresh application to the same authority. I wouldn't recommend going to another authority because they will just make inquiries and treat you with great hostility because they think you're trying it on by going to them, and they'll be stupid enough not to notice that what happened before. But if you go to the original authority, what they should do, and what they may do wrong, is say, no, we've already dealt with you, we're not going to do anything. But that's unlawful. What they have to do is make a decision as to whether to process what they're going to do about your new application. They could write you a letter saying we refuse to process your application because it's a repeat application with no merit, which you could challenge by way of judicial review. Or they could say, as they should do, we accept you're homeless, but and you're still in priority need, but you're intentionally homeless because the reason you're homeless is because of what you did regarding the previous accommodation. And then you could ask for a review of that decision, and that would open the door for you to have the argument which you were locked out of about the suitability of that accommodation. Because if you say, no, I wasn't intentionally homeless because that accommodation wasn't reasonable for me to occupy, or the thing I did was not a deliberate act or omission. Well, I suppose they could say it's a deliberate act or omission which led to you not getting it. But if you could say it was made in good faith, or you could get round it, I think, and have an argument to say that refusing something unsuitable couldn't be treated as intentional homelessness. And then even if they did, even if you were unsuccessful on that, you'd have section 190, 190, which means that they have a duty to assist you in obtaining accommodation, even if you are intentionally homeless, if you're in priority need. So keep on with the same authority, and hopefully everything should be all right. Because at some point they'll say, oh, this is just silly. Because if they can see that it was unsuitable, they're not really going to want to go through all those hoops. Although some of them may, some councils are so aggressive, once they've sort of declared that you're no longer their friend, they'll just fight you all the way. And that's what I'd say.
And having worked in the council and seen how that works in the back office, like in terms of just someone's dared to do something the council didn't like, they will absolutely kind of just be as unhelpful as humanly possible and act unlawfully and all the rest of it. So you're not a situation you want to get into if you can avoid it.
So the other thing, of course, that I forgot to mention is that just because if you go outside the section 202 review 21-day deadline, that doesn't mean that you can't challenge the decision. It just means you can't do it by way of a section 202 review. You've still got 3 months to judicially review them. And so you can say, well, are you really denying me the chance to challenge this internally? And they'll say, yeah, we are, 21 days. And you say, well, okay, then I'll invite you to reconsider. And if you don't agree to that, if you don't reconsider, I'll go to the High Court.
And Will just make, I mean, Will just did a very good job of explaining it. So you might want to rewind that because there's a lot of information there. This is definitely a situation you want to get a solicitor involved, because to do what Will just said, you need to you need to have a solicitor on your side to kind of pull that one off, because you can just imagine like how, yeah, the council will just stop writing to you. You know, they'll stop replying to you a lot of the time. So you need to get a solicitor right to the legal team to get it work. Guys, can you hear a beeping come through your? Is it coming through the microphone? I think it's actually all right. I'm getting like notification after notification for some reason. But anyway, so next question, question 9. Carison, Will, if you need to head off, it's now 8:30. So thanks very much for your time. We'll try and get through the rest of these questions. So from this point on, guys, we're going to call it a close on new questions on the chat. So if you put your question in there already, great, we'll get to it. If you haven't, then save it for next week. So number 9, I know someone who's 63 years old, who's facing homelessness. What would the council's responsibility be to house him, and would he be put in a hostel or temporary accommodation due to his age whilst waiting? So really good question. This comes back to our kind of conversation earlier about being automatically in priority need. Now, age is not one of the automatic characteristics, but it is relevant. So you can be in priority need through vulnerability because of your age, but there's no set cutoff point. So, so I always use the example of Ranulph Fiennes, who I think recently walked across Antarctica, age 70, whatever he is, 76 or something like that. He's not vulnerable. He's not vulnerable, certainly from the point of view of his physical health. He's fit as a fiddle, really. But you might find somebody who's only 55 and they're actually present as quite frail. So the question, going back to this kind of very short definition of vulnerability, it means something very specific within housing law. Search on the channel for vulnerability. So the best video on the channel it's called A Judge Explains Priority Needs. So if you search for A Judge Explains Priority Need on the channel, you'll get Sarah Steinhardt explaining what vulnerability means in detail. And we will did a couple of longer, like going deep dives onto a couple of cases, which I think did a good job of explaining what it means as well. But effectively, what you need to be able to show is that there's something about being 63 years old, which means that you're noticeably more at risk of harm than a healthy and robust person would be. And that there's something about that which means you're going to struggle to deal with the consequences of being homeless. Now, with age, generally speaking, you're going to have to probably going to have to throw some kind of medical issue, like let's say arthritis, just to kind of stereotype old people. So apologies for that. But arthritis is actually a really good example of a condition which would very easily mean you're in priority need because it's affected by cold weather. And therefore, it's very specifically going to be affected by being homeless. So it may well be that you're 63 years old. You may be in priority need, you may not be. The good news is that your local council probably has, well, a lot of the time has a very short waiting list for older people's accommodation, so sheltered accommodation, and that could be for anyone over the age of 55. Certainly local to me, that's where it is. So I've worked with people who literally got an offer of housing the same day, got the keys the same day because there was loads of voids in older people accommodation. They moved in, they've lived there ever since. So absolutely worth making a homeless application if that's not already obvious. You're not guaranteed to be in priority need, so the council might not have a duty to house you. If there's no reason to think you might be in priority need, then the council won't have a duty to house you at all, really. But what they would then do is get you onto the housing register, because you're still owed the prevention or the relief duty at that stage. You'll get reasonable preference, and it may well be that that's actually quick enough. You're able to get somewhere fairly quickly through through kind of sheltered accommodation routes. Karis, you got anything to add to that one?
Sorry, just with what you're concerned about being put in a hostel or temporary accommodation, temporary accommodation is usually like a B&B hotel or a hostel. So they would take that into consideration in your age and needs when looking at accommodation for you, but advocate for and focus on why they don't want to be in a hostel.
Yeah,
And what is the reason surrounding that?
Yeah. So I mean,
Has to be
you want to
suitable.
you want to be able to show, make an argument to say there's something about my particular physical or mental health which means I'm not going to be able to deal with being in a shared environment. And yeah, essentially, probably in the real world, you're probably going to need to have medical evidence to back that up, and a solicitor sometimes, because suitability is probably the most difficult aspect to argue as a layperson. It's yes, it's actually it's probably much easier to it is much easier to do it as a solicitor, because often you're going to get them on a technicality anyway, because they haven't properly assessed you or whatever else it might be. And there's just okay, this might actually be the same part of the same question, but we'll do it as a separate question. It's the same person. So someone has sensory issues as well as being autistic and been referred to the mental health team. So I'm going to take a guess that that's kind of the community mental health team. Would it be possible to tell the council that hostel is not appropriate accommodation? So yeah, as we just said, so you need to go further than just saying, this person's got a diagnosis of autism. You'd have to kind of go further, but you may well be able to do that. So actually, this person has autism. They have kind of, very real difficult time dealing with loud noises and unexpected events and all that sort of stuff. And therefore, the treating professional is basically going to say, we don't think this person is suitable to be in shared accommodation. And that holds a lot of weight. A lot of councils will still ignore it. So you still probably have to get a solicitor to kind of make them not ignore it. But from a legal point of view, I'd say there's a good argument to make there. It's just there's no kind of like magic bullet for that sort of thing, really. The more evidence you can get, the better. Right. So next question. If I can manage to copy and paste it properly, it's been a bit weird. Let's try that. So yeah, question 11. If a family is overcrowded by law, the room standard size, homeless, can the council accept the family under the prevention duty, or do the council have to provide their relief duties? So, okay, so interesting question. Just because you're overcrowded by the legal definition, and there's two legal definitions, I think, but just because that in itself doesn't make you homeless. So what you have to do is you have to show why it's unreasonable to continue to occupy the accommodation through it being overcrowded. So, which is it's a very different argument, basically. And overcrowding is a kind of an aspect of law where councils can legitimately compare you to other people living in their district. Usually they can't. So something like if you're vulnerable or not has to be an objective test. It's just about you. Whereas overcrowding, let's say you're in Tower Hamlets, which is notoriously kind of an overcrowded sort of district. It might be that a lot of people are legally overcrowded, and the council can say, well, loads of people are legally overcrowded, therefore, you're no worse than most people, therefore we're not going to accept you're homeless. So you need to go further than just showing that you're overcrowded using that room standard size. I don't know if there's like a kind of a sort of one size fits all thing. In my experience, unless you're kind of like two people overcrowded or even three people overcrowded, you're probably not going to win that argument to say it's not reasonable to continue to occupy. And maybe even further in somewhere like Tower Hamlets. But if once the council accept that yes, you are homeless, they have accepted it's not reasonable to continue to occupy the accommodation, then at that point, yes, the relief duty is triggered, not the prevention duty. So that in one sense, the prevention duty shouldn't really factor in a situation like that, unless, let's say, you've got a pregnant mum in the household who is within 56 days of giving birth, at which point it would be overcrowded. So that would be the only sort of situation where it would actually work, being the prevention duty kicking in. If you're homeless, if it's unreasonable to continue to occupy, then that's the definition of homelessness, and that is where you go straight to the relief duty stage. So yeah. Will or Karis, you want to add anything to that? I mean, I'm not terribly experienced with overcrowding cases, to be honest, but that's my understanding of how it works. Cool. I'm going to take everyone's silence as a affirmation there. So guys, just right. I wish I could close the close the questions. We've got a bunch more questions in. I'm going to try and finish them basically tonight. But Will and Karis, you got to head off. Just do so. So, question 12. A friend left supported accommodation due to very unsuitable and is now sofa surfing. Can she remain on housing registry in borough where supported accommodation if sofa surfing in a different area? My answer is probably not on two counts. So one is that I'm assuming that someone who was on the housing register because they're in supported accommodation, if they then leave that accommodation, that they'll, yeah, let's just kind of, we'll come back to that in a minute. But if you've left that accommodation, you'll no longer qualify for that route into the housing register. So no, um, your option would therefore be to make a homeless application, and at some point, not in the initial stages, but at some point, the council will look at, okay, why did you leave that supported accommodation? And you may well have a very good reason. The supported accommodation is often terrible, horrendous, and certainly in Bedford, we've had a number of cases where we've been able to show that even though, yes, they were able to live somewhere, they had a license to stay there, they had a legal right to occupy it. The environment was having such a big impact on their mental health that they were legally homeless already whilst they were living there. So, but that's the kind of argument you're probably going to have to try and run. So, in one sense, the fact you're sofa surfing in a different area is probably not the relevant fact. The relevant fact is probably you were on the housing register because you were going through the supported accommodation process. I'm guessing. I need to again see your local policies to know that for sure. And my guess is the local housing allocation scheme will specify that if someone loses, they'll class it as that you've lost the accommodation, even if you had a good reason for it, because they won't actually ask you. But they're probably going to say, yeah, if you abandon the property as they'll see it, you basically count yourself out as that of that route into the housing register. So just to give a bit of context, just to make sense of that, a lot of housing registers, not all of them, but a lot of the housing register policies will basically say that for certain registered social supported accommodation providers, if someone lives there for 6 or 12 months, then they'll get onto a banding on the housing register. But I think if they would then lose that accommodation, then they would probably lose the banding as well, would be my guess. But again, you need to check out the local policy. Yeah, someone says, yeah, same thing with hostels, one rule break and you're out. Yeah, I mean, as I say, supported accommodation are very good at generating intentionally homeless people who didn't need to be. Interesting question here. So question 13. Have you ever seen a subject access request unveil malicious acts, for example, retaliatory behaviour after a complaint? Yes, I have. It's quite rare because obviously most malicious housing officers are quite good at hiding it, is probably my way of saying it. But I have seen them, yes. So certainly email trail. I've seen email trails between different housing officers where they're arguing about a particular point, and one housing officer is trying to do the right thing and the other housing officer is trying to do the wrong thing. So it does happen. I guess we want to be a little bit kind of, I guess, pedantic with the word malicious. It's quite difficult to prove malice within law, but I know what you mean. I know you probably mean it in kind of a everyday sense. Yeah, but obviously, when I worked in Bedford, the kind of conversation. I remember one guy in particular. He was in temporary accommodation. He was refusing an offer of accommodation, just digging his heels in, and they just, they would just they're just completely lawless when it came to dealing with him. But it's all verbal. It wasn't a whistle blew about it, so it wasn't like I kind of let it go. But obviously a lot of they weren't writing down what they were saying because they weren't stupid. They actually knew what they were doing. So it's probably quite I would say housing officers are malicious a lot of a lot more of the time than they get caught for being malicious, if that makes sense. So there's they probably do it quite a lot, but the number of times there's going to be smoking gun evidence is probably quite low. Will, did you want to say anything about that one?
No, not really. I mean, other than the fact that it's conceptually possible, and it does happen rarely, but often. I mean, I'd go be cynical and say that if they're going to behave like that, they may well have removed the records before they were disclosed.
Yeah. Deletion of records happens as well. Yeah, for sure. So there's just a question coming in again, which has got personal data in it. So I'm just going to remove it. It's nothing personal. It's just that I don't want people to put personal data on there. So if that person could rephrase the question and probably put it onto the comment section of a video, because we're not going to have time to deal with it tonight. Then there's just a follow-up question to a previous one. Let's go back. So I think it's this one here. So question 8, could they not write to the council and now accept the new temporary accommodation? So if it's not too late to do that, then yes, they could. But I think a lot of councils say, no, you've had your chance, end of. But certainly it's worth a try. You don't lose anything by doing that. Look, I mean, look, I slate housing officers a lot. some housing officers are fine. They're just nice people and they've got a difficult job. And they will be reasonable. You know, they do actually, they do turn up at work to actually get people housed rather than not house people. So it's certainly worth a try. But I would say I'm not sure how likely that is. And then so there's just again just a bit more where we've gone here. So there's a bit more. So they were offered new temporary accommodation before accepting a therapy report, maybe an occupational therapy report that's referring to. So OT reports, if that's what we're talking about, would be very useful, and that might actually provide the information you need to show that it was not reasonable. Let's say it's something really obvious, like you're in a wheelchair and you told them that you're in a wheelchair, and they provided you with a fifth floor flat or something, then an OT report would potentially kind of make the difference there. So yeah, that could be like that would if an OT report says that accommodation was unreasonable for that person to live there, then that's great. That's probably about as good as you're going to get, to be honest. So yeah, so we're going to call it a night there for the ones in the chat. So again, sorry if we missed you for tonight. Stick the question into any video comment section on the channel, and I'll get a notification and I'll bring it to the next one. Or you can ask it at Will's live stream on Monday. So we'll be with Will on Monday evening. So feel free to roll that question over. But for the time being, because the time is getting on tonight, we're going to go back to the questions that have come in through the week from the last week. So we've done that one there. This is a really interesting one, and I don't know the answer to it. I can kind of guess, but so this one, again, the reason I'm doing this one last is because it's not anonymized. But and my local connection is the 3 out of 5 years in the area. I'm 1 week short of the full 3 years, and my housing officer said she may refer me to another council. Can I appeal this? So, okay, so you have local connection through residency, either if you've lived somewhere for 3 out of the last 5 years or 6 out of the last 12 months. And this person has essentially, they moved out their last area 2 years and 1 week ago, and they therefore technically lose that local connection through that way. Now, I don't know the answer to this, but I'm going to ask Will and Karis about this in a moment. My understanding of this is that potentially you could challenge it because this criteria is never set out in law. It's kind of like an agreement between councils, this 3 out of the last 5 years and so on. And so, the kind of, I guess it comes back to what's the spirit of the law? Well, the spirit of the law is this person probably does have connection to that previous area. So, yeah, I mean, is there any kind of definite way to challenge that referral back to another local authority? Just basically say, I'm 1 week short of 3 years, but can you still not consider that? Any experience that one, Will?
Well, no, I haven't, but I would have thought that if it is the case that it's the previous three authority and that they can't, it's not a situation of just going back next week when you'll have the full 3 years. But if it's going backwards, then I think you'd be stuck because it's exactly the sort of thing where you'd get a judge saying, "Oh, it's very sad, but that's what the law is. That's what the law says." And it's like if you lose an election by 2 votes, you're still lost. So I think it would be difficult, and you just have to look for other aspects of local connection. I can't see that you could go there and say the law, the law or the code of guidance or whatever it is that says 3 out of 5 years, and I've only got 2.9 years. So, but for some reason that shouldn't apply to me. And it's a really tough local connection.
Yeah, I did go back to them and say, have they got family living there? And the answer was no, certainly not close family. So, yeah, I mean, I'm just thinking aloud more than anything. You actually get local connection through volunteering, which might seem like a really weird one because you get it through employment, and technically volunteering is a type of employment if you're doing it right. There's a case, if you're interested in that, check out Fox v Ealing, which kind of set the precedent for it. Now, I'm thinking aloud when I say that, maybe that person could apply for a voluntary role in that other area and see if that kind of works. But probably just me thinking wishfully rather than actually giving anything that's going to be useful. But it's just interesting that you get local connections with volunteering as well as kind of paid employment. Karis, do you think, and to add to that one?
It's probably more of a question. Will, so wouldn't you argue the strict adherence to the rule would be unreasonable hardship and exceptional circumstances of the limited time and demonstrate why moving to another area would damage your well-being. Would that not be a route, I
I mean,
suppose?
I can't see it applying any more than sort of any other aspect of saying the law, application of the law is going to be is going to be adverse to me. I mean, it's just that local connection isn't something that is measured in anything other than the limited criteria. That's the problem.
Mm.
I was going to ask a question, which is maybe sound a bit trite, but how difficult is it to get a job in McDonald's these days?
I mean, it's probably, yeah. I mean,
Really,
or a job somewhere. Yeah, yeah.
because you could. I mean, when I was younger and I was working in catering, there was always this sort of safety net of McDonald's if you really wanted to go work. Nobody did want to go and work in McDonald's in those days, but rather work in Pizza Land. But um, there was this thought that you could do if you needed to. So in theory, I've often wondered this: if you got a job in McDonald's and said, "Hello, it's me again. I'm working in McDonald's now. I've got a job." It'd be hard for them to say, "Well, that doesn't count."
I think it'd
Um,
be impossible for them to say that because I think
you've
so.
only been
Whereas,
there a week.
yeah, yeah, because whereas Part 6 would specify, or could specify you need to have done that job for a year. Part 7 doesn't specify any time period. If you've got a current employment contract in an area where that's where you're working, that would be enough. So I think
Yeah.
you could that would count. Um, yeah, which is kind of why I said about volunteering because that would potentially be easier to get than a job. But yeah, I mean we're assuming here this person is able to work. So if you're not, then I think that option is potentially not available.
Yeah, sort of.
Um, but yeah, yeah. I mean, as I say, yeah, that's the answer I feared. I wonder because just to make the point that there are some bits in the code of guidance which would step outside of those strict criteria. So, for example, if because it always specifies settled accommodation for that period of residence, but for people rough sleeping, it kind of gives an exception within the code of guidance and say, well, if you're actually in the area, then that would count as residence for the purposes of the act. So, yeah, I think it sounds like our answer is bad news, but yeah, that's what it is what it is.
Another thing I think is that the courts are going to be very wary of allowing any of being flexible on this because then they're going to think if I allow this one through, then there's going to be loads and loads of cases where everyone's going to say, well, it shouldn't apply to me, and then they'll be having sort of half-day hearings about reasons given, and so they're probably under pressure to say no, you've got to take a really strict view.
Yeah. Um, cool. Right. So, I mean, I should say one more thing about that local connection question. Making the council like so basically not giving up and making the council make the referral might actually end up being quite effective. I did a video about it recently. I think the title of the video was like councils gatekeeping other councils or something like that. And basically, it was a case where there was a referral being made. It was like some councils just west of London. It might have been like I can't remember now. Yeah, so like around Woking area, it wasn't Woking, but somewhere like that. And basically, a referral had been made, and it should really only take like a week or so for that referral to be completed. But the other council basically just kept this council, and so it actually took months in the end. And I just wonder, actually, if this person sticks out and says, "Well, okay, I really want to be in this area. If you want to go and refer me to the other area, get to it," then the other area, that housing officer might just kind of say, "Oh, do you know, I can't be bothered with that. It's too hard to make a referral under Section 198," and just basically say, "Okay, well, we're going to accept it." So you don't lose anything by doing that. So you might just want to try that as well. Anyway, question 15. Oh, by the way, guys, if you find this stuff useful, please do the old liking and subscribing nonsense. It does actually help the reach of the video, which is good. And I'm hoping that there is some information in what we're saying tonight, which is useful. So it just helps other people see it, basically. So yeah, please do that. It'd be really great. And just to reiterate what I said at the beginning of the video, if you didn't catch it, um, we're offering our training free to councillors and MPs. And so therefore, if you have, someone's already mentioned they've been in contact with the councillor, just send through the Eventbrite link to the councillor and say, look, there's free places if you're interested. It's designed to kind of equip council, well, it's designed to equip anyone really to understand the kind of basics of the law. And for a councillor, it would mean that they would be able to actually be in a position to be more curious when a council tells them some nonsense and actually potentially get more people housed. So yeah, that'd be helpful. If you go back on the live stream chat back up to the top somewhere, there's the Eventbrite link back there. It's one of the first ones of the night, actually, like third message of the night. Um, So, last question of the night. If you missed it tonight, as I say, come back on Monday for Will's channel on his channel. It's called Will Flack Law, or back here next Thursday. If you want to put the question into just a video on the in the comment section, I'll get it. In fact, there's 2 more questions, but this is the penultimate one. So, hi, I've been homeless in Coventry since June. I've been applying for homes through the Home Finder website, and I'm band 2. My housing officer has only told me to look privately rented properties, but suggested nothing else to help me and my circumstances. Is there advice? Is there any advice you may be able to give me on this? If you have time, thank you for the video. So, okay, let's this is yeah this is worth unpicking a little bit. Appreciate it's been quite a long stream. I've been talking already, but so made a homeless. I'm assuming we made a homeless application in June, and the only reason you'd still be rough sleeping at this point would be that there's no reason to think you might be in priority needs. There's no mention here of interim accommodation. So the Coventry Council is basically saying this person rough sleeping is there's no reason to think they might be in priority need. Now, bearing in mind, part of the assessment of priority need through vulnerability is there someone's ability to find accommodation. So if this person's still homeless 6 months later, then that would have a bearing on whether they had, whether there is an impairment that is having an effect on their ability to find accommodation. So there might be some new facts there, which a lawyer would kind of take that and say, well, actually, let's make a fresh application anyway, because the circumstances have changed and there is now reason to believe they might be in priority need. So that's what I'm assuming. What I'm assuming has happened here is the council saying, you're not in priority needs, so we're not going to offer you any help other than the normal relief duty stuff, which is going to be, if you go find private rented accommodation, we'll pay the deposit or something. But again, this is a situation where the council probably isn't following the law here, because the relief duty should only really last for 56 days. And if the person's still homeless, then that's the end of the relief duty stage. Although there is the ability to extend it a little bit, you shouldn't be in a situation where, the relief duty is still potentially engaged. It's just a bit messy. And really what you want to be focusing on is showing that you might be in priority need. That's the thing which is going to get a roof over your head. So, yeah, that's yeah, and I guess it's very difficult to unpick that quickly. But again, if you look on the channel, there's some videos about priority need to kind of give you an idea of how it all works. But yeah, that just seems to be in a situation where I don't know Coventry Council at all. I never dealt with them, but my guess is that they haven't properly considered that person's vulnerabilities, and that person actually should be in TA anyway. So that would be my answer there. I don't know if you want to add anything, Will or Karis. If not,
I could just add a tiny bit to it, because it is a pretty awful situation, and what it does involve is that basically the council have done absolutely nothing. I mean, telling somebody to look for private rented properties is basically saying get lost, go and find your own property, which means that they probably, I mean, it comes back to, and I'll say it again, the Section 189A of the Act, and the duty to carry out a proper assessment of somebody's housing needs and how they became homeless, what would be suitable accommodation for them, what support they need, and then to come up with a personalised housing plan of what the council can do to help that person. And if the personalised housing plan simply says go and look for your own accommodation, I think that should be open to challenge. That doesn't mean that the challenge would result in them having to find you a place, but I think that it would be open to argue that they should have at least done something more active to help you find a place. And plus, as you say, Mike, the fact that somebody hasn't been able to find accommodation themselves for 6 months means that they may come within, there may be some reason for that, which would give rise to priority need and vulnerability, because coping with the effects of homelessness, by definition, doesn't just mean sort of not dying because you're exposed to the elements. It means being able to get yourself out of that situation. And if you're sleeping rough all that time, it's arguable that you've been unable to do so. So if you can join the dots and say, I've been unable to find somewhere because of, and then there's something about you that makes you vulnerable, then have a go. I mean, you may be able to challenge that. So I hope that gives you some hope.
And I'd also guess I'd hope there'd be a decent homelessness support service in Coventry that can also help you navigate that, because what we just said was quite a complicated way of posing the argument. But I guess that's what professionals should be there to do, is to actually help people navigate this system. Brings on to our final question for the night. Hi, I've just been given Section 21, been here for 30 years, always paid my rent on time. Do I have any right as been here long time, maybe classed as sitting tenant? So my understanding is no. A sitting tenant, I think, is when the landlord agrees for you to stay there whilst they sell the house, which doesn't sound like it's what we're not talking about that here. So yeah, so being in a property for many years, unfortunately, gives you no right at all. You know, they can evict you just to say now. Whether there's I don't know what the deal is with tenancies 30 years ago, whether there's something different. But yeah, Will, you've been around that long, so you
I
you
have,
could tell
yeah.
us.
Yeah, I mean, I would say that you could be tenant of the year, or win the sort of 10 years running, and still you'd have no defence to a claim for possession based on assured short-hold tenancy, which is one of the evil things about the regime. Um, 30 years ago would still be post. Well, hang on, there's some little hope. Hang on, 30 years ago would be 1994, wouldn't it? And I think back in 1994, you could only be an assured short-hold tenant if the landlord had given you notice that your tenancy was going to be an assured short-hold tenancy. They later reversed that so that you were by default an assured short-hold tenant until unless you were given a notice saying you weren't, so you're just an assured tenant. So it may be that if you were there 30 years ago and your landlord granted you an assured tenancy but not an assured short-hold with a specific notice, you would have a full defence to a Section 21 now, which would be that I'm not an assured short-hold tenant. That's grasping at straws a bit. A
Well,
sitting tenant
better
is
than
a
nothing.
Sitting tenant is a term I think that predates the 1988 Housing Act, and it goes back to old sort of Rent Act tenancies where a sitting tenant basically meant somebody you couldn't get rid of because the law was so favourable to tenants compared to now that really, unless you could show they'd breached the terms of their tenancy, it was very difficult to get them out. And so you ended up sort of paying them off to leave, which was one of the reasons, as the government saw it, that they introduced short-hold tenancies because the private sector market was, I don't know if it's true, but at the time the propaganda was that they had to introduce this because nobody was going to rent private properties because they would all become sitting tenants and you'd have to sort of pay them ridiculous amounts of money to leave. So I hope that helps, and good luck with challenging that.
Yeah, I mean they paid the landlord's mortgage probably 2 or 3 times over in that time. So yeah,
And remember, sorry, that there's if you can get somebody to go through that Section 21 notice and your circumstances, and when the landlord issues possession proceedings, they will have to exhibit all the evidence to show that that notice is valid. And if you go through that, and finally examine it, it's quite easy to find that the landlord has made a simple mistake, which may cost them the whole exercise.
yeah. So again, I mean, yeah, again, it kind of comes down to whether there's any local kind of advice services that would be able to give that level of detail. But yeah. So as always, go back to what we said earlier about solicitors. Check out Will's website and have a look at the list of legal aid funded solicitors. Anyway, guys, thanks very much for the questions. And as I say, we haven't had a chance to answer all of them, but if you just want to roll those questions over to either Monday's one with Will, or if you put it on the comment section of the channel, I'll get an update next week and bring it next week. Again, just please don't put them in the first person, just so you don't have to put personal data here. Other than that, hope this has been helpful, guys. Keep doing what you're doing. Perseverance goes a long way when you're fighting with council. So and having a solicitor goes even further. So have a look for solicitors if you can. But yeah, we'll see you next week. See you on Monday if you can on Will's channel.